to all of you. Justice Banerjee, President Prashant Kumar, Dr. Pinky Anand, Anindita, friends from afar. I noticed that a large number of you have traveled specially for this seminar, and welcome to New Delhi for that purpose. This is, at a certain level, a baby step on the part of Bar Association of India, because we were not very certain as to whether we should have a physical event or not. But we reckon that we have to now move back into the world of physical events, meeting each other in person rather than just on a screen. And that is why we thought that let us launch our physical calendar once again with a seminar on this important subject relating to personal data protection and inevitably dealing with privacy. I also notice amongst the audience, apart from several friends and distinguished members of the bar, law students. I welcome each one of you to this session, and for the sessions that follow. I've had the advantage of listening to some of the speakers who are slated to follow in the working sessions. And I can tell you that they are very, very engaging speakers, and they're just full of what I would say content. Their speeches and their presentations in the past, which I witnessed and which some of us have had the advantage of also reviewing, because it's very, very unusual. The special work that they do, the specialization and the insights which they have developed over the years. And in particular, I think, given the fact that many of us here in this room are generalists, we tend to miss out on some of the nuances with regard to exactly what is happening in this field of data protection. And I think the purpose and the object of this particular day-long seminar is essentially to educate ourselves, to ensure that each one of us leaves this evening better informed and more aware, I think, of the challenges not only that society faces, that we in India face, but very particularly the challenges which are presented by this data protection bill, which perhaps in 2022, very likely, or if not 2022, at least sometime probably in the next year, is going to become a law which will govern almost every aspect of what we do. And this brings us to the question as to whether at times it's better to have no law than to have a bad law. And when I look at the importance of this data protection bill, I think it has almost the significance of a constitutional amendment. And I'll indicate what I mean by that. I think there are a few statutes which get enacted through the parliamentary process, which have a special and elevated meaning in ensuring that rights promised under the Constitution are realized in a meaningful manner. One which comes straight away to mind is our right to information, and the whole concept of freedom of information, which was articulated in Supreme Court of India judgments, finally finding itself engrafted in the form of a statute and therefore available for the general citizenry to exercise. And I think the degree of transparency, the degree of accountability that one law has brought has been tremendous. And it's now virtually become an article of faith as far as governance in India is concerned. If something is available in government records, you and I can reach out and require the government to make that disclosure. So I think overall, in terms of how we run the system, how we work our constitution, this has been one statute which is extraordinarily important in preserving, protecting rights, and in also defining spaces for us as citizens. My sense is that the Personal Data Protection Act, as and when it gets passed, is going to have ramifications and impacts which are as much and as important and as elevated as something like the right to information. And the reason for this is that as we live through this enormous transformation in technologies that we use and we adapt, this very disruptive process, this age of the early internet, where almost everything that we take for granted, the way we consume news, the way we order food, the way we address courts, all of that is being disrupted and is being transformed. And the reason, of course, is the internet and its pervasive nature. But coming along with this internet are new challenges to old values. And the question is as to whether these old values, which we find enshrined in the Constitution, are going to survive this enormous technological disruption that we are now undergoing. Part of the answer will be, I suspect, not delivered by local legislatures, but will be developed and answered at a global level. What do we as a species want? I think with the internet and the extensive manner in which it reaches out and it pervades our lives across the globe, it may no more be just possible for a local national legislature to dictate what it wants of its citizens. I think we're far too interconnected for that. So there will probably be global norms. They may not be universal global norms. You may find that certain countries or sets of countries adopt a certain regime, other countries adopt different regimes. That is for the future to tell us. But as we debate and discuss this bill, I think what's really crucial is just 3 or 4 factors that I want to mention, and I'll leave it to for deliberations and discussions further on in today's seminar. One important point I want to mention and project is that when you read contemporary literature on the evolution and development of technology, one realizes there is not just one way forward. At every stage when technologies develop, which are adopted by, the big tech companies, which are adopted by government, there are choices. And I think that's very, very important to keep in mind. As laypersons, we feel, oh, this is inevitable. This is bound to happen. You can't stop technology. It's a sort of an arrow which has been shot out from the bow and it's going to land at some point. That's not the case. And I think this is a very, very important insight which I obtained from my readings, which are there are options and choices which big tech has all the time. And they oftentimes adopt a particular route because it is more lucrative for them. But we as citizens have to make a call as to whether these technologies which are being applied to us across the board are really consistent with the values which we hold dear and which are framed in our Constitution. So that's one. The second point which I wish to emphasize, and I'm sure it will come out in the course of deliberations, I know that it's certainly a part of the first working session, is the relationship between the citizen and the state. The relationship is constantly changing. We know that. But when it changes in a manner by which we tend to forget the extent of the space we enjoyed and how that space is getting constricted is something I think we need to be alive to, and I think it's something which we need to fight for to protect our spaces. I come up with just one example which has nothing to do perhaps with personal data protection. But I can see that our spaces and freedoms such as dignity are certainly expanding. I think one of the great initiatives which has taken place in the past 6 or 7 years, beginning 2014, has been the very strong and powerful drive by the government in ensuring dignity by having a campaign to completely abolish open defecation. I think that has enormous advantages in terms of dignity. It has enormous advantages in terms of health and sanitation and, huge downstream advantages. So that's an area where we've expanded as a society. But equally, I find that there are several areas where our rights are shrinking, and we have to be very, very alive to that. The third point I wish to mention is trust. Who do we trust? And should we trust the state less? I think for far too long, our judgments from the Supreme Court and the guidance we receive, not just from the Supreme Court, but as we work in our day-to-day lives, is, this is our government, they are our elected representatives, it's our constitution, surely we must trust the state. I feel that the balance in the constitution, the balance between citizen and state, gets skewed against the citizen if we are so trusting of the state. I think we need to recognize that while it is an elected government, and while it is a government which has to validate itself through performance because of the electoral polls that we have, I think we need to create within the statutes and within the state structures organizations whom we can trust. This is very important in the context of the Personal Data Protection Bill. Is there going to be some repository over there whom we can make complaints to? Who is going to store our data? Is it going to be subject to some oversight by people we trust, or is it just a blank check which is being issued to the union government and the union government can do exactly as it likes? Finally, I want to flag the commercial imperative. I think as we move forward, we have to recognize that both for economic growth as well as recognizing the real world and the fact that Indian corporations and Indian techies and Indian entrepreneurs are not just competing amongst themselves, but are competing in a global environment, we have to recognize that yes, there will be commercial interests which do not want to be hemmed in very desperately. So there will be an element of balancing which takes place in this personal data protection bill, but how much should we yield is an important question which I hope each one of you will reflect on and which I'm sure our speakers will speak to. There is Gopal Krishna Gandhi's 2015 translation of the Tirukural, which I'm sure some of you must have read earlier, but I just happened upon a new reprint which Aleph has put forward. And it has a lovely verse which he translates, and it goes thus: "If those who need you can reach you, you are amongst the world's courteous few." And I thank Justice Indira Banerjee for her immense courtesy in agreeing very graciously to be present this morning to address all of us. We anxiously look forward naturally to what she has to say. But I must recall, and I'm sure many of you were present, this was pre-pandemic, so it's more than a couple of years ago, the outstanding and very engaging speech which she made impromptu at an earlier Bar Association of India function where we were felicitating a large number of stalwarts from the bar. Justice Banerjee, of course, is no stranger to the Bar Association of India, and we count her as being a member and a participant in previous activities as well, apart from her excellent speeches. So I thank you very much for sparing your time to address this particular, address us today. I'll leave you with a thought. There's some excellent insights in a new book released by Siddharth Sonkar. He is a recently minted graduate from NUJS at Calcutta. And he's written this slim volume called What Privacy Means, Why It Matters and How We Can Protect It. And when I was sort of skimming through that book, I found a reference to sensitive personal data. And amongst the sensitive personal data, which even under the new bill is afforded the highest degree of protection, is what is termed as official identifiers. The most obvious official identifier, of course, is the Aadhaar number. And here we come to the Supreme Court rules, because I was, a few months ago, we had settled a petition which was to be lodged before the Supreme Court of India. And the three petitioners were all retired personnel from the Indian services and the Indian Army. One of them was a general who had, in fact, petitioned the Supreme Court in the privacy case, Major General Vambatkere. And the draft was fully prepared. They wanted to canvass the position against hate speech. And they said that, look, we have been members of the services. We have all our regiments which we have commanded have people from different faiths. We cannot afford this hate speech. So anyway, that's the petition. But we couldn't get into the Supreme Court, and why was that? The Supreme Court registry insisted on a full disclosure of the entire Aadhaar number. So we said, how can that be? And these petitioners were very anxious. They were saying that, look, this is something confidential. It's recognized as sensitive personal data. If you advertise and disclose this number on affidavits and where have you, it can be misused very, very badly. And I'm sure there will be examples and instances of misuse which come forward. But then there was a back and forth, and eventually we were able to redact some of those, the numbers within the Aadhaar number with XXXXX. So you often have a situation where even though the Supreme Court judgment says that you cannot insist upon Aadhaar as your sole identifier, and the UIDAI itself says, please be very cagey and reluctant to disclose this and advertise this number, you have situations where we're sort of out of sync with even the law which has been declared by our court. So I welcome you again to this day-long seminar, and I thank you all for your time.
Thank you, Mr. Divan, for flagging all the conundrums that we are all aware of with regard to data protection law, especially sharing the lived reality of how difficult it is even to get a pass or a petition filed in court because the rules do not permit it. So therefore, there is a reality, there is a virtual reality, and there is a lived reality. And here we are here today to discuss all of that and somehow learn how to navigate through a method which is known to us as lawyers. Thank you for the excellent speech, sir. Moving on to the next speaker, we have Mr. Prashant Kumar, who is the President of Bar Association of India and past President of Law Asia. Mr. Kumar, please.
Thank you, Anindita. Honorable Justice Indira Banerjee, Judge Supreme Court of India, my very dear colleague Shyam and Pinky and Anindita, all the delegates, Vice President Uday Warunjikar, and everyone who has come from near and far, I welcome you and I wish you Eid Mubarak. Now, this is the first physical event of the Bar Association of India after December 3. And we are very fortunate that both the events were graced by Justice Indira Banerjee. So in December 3, we celebrated Lawyers of India Day, 2019. And after that, here she is with us to guide us and to bless us. So a big hand to Justice Indira Banerjee. Now friends, Shyam who is one of our celebrated privacy warriors, has basically laid out before you the entire spectrum of what issues the Data Protection Bill and the law which is being proposed after having gone through a recommendation by a committee headed by a former Supreme Court judge, then being drafted by the ministry, after that going to the Parliamentary Select Committee. That report is there. And here now we have a text of the bill which is called the Personal Data Protection Bill 2019 and which has been revised to be Data Protection Bill 2021. Now friends, apart from other things, it is data literacy which is very, very significant. And again, you know, taking from Shyam's point, when we talk about Supreme Court or the constitutional judiciary, which includes high courts, one of the things which, when we started engaging with how to permeate information technology into judicial system, and my young colleague Amarjit Bedi was part of the Asian Development Bank Assistance Project for this purpose way back in 2008-9. Our main concern was that how for an independent judiciary, the entire IT infrastructure is to be provided by the government. So the very fact that NIC is the backbone of the entire judicial infrastructure is something of concern by itself. Because an independent institution which in so many areas and mostly have to decide citizens' rights against the government, to have the entire data, entire working, every single information in the hands of the government is by itself a huge concern and at some time must be addressed. Because otherwise, the way especially now the new tools are available and the way things are there, how the security of even judgments being written and on the same kind of network being uploaded, revised, when a breach can occur, it's only when somebody finds it actually that it will get flagged. Otherwise, its impossibility cannot be ruled out. So I think when we are talking about data protection bill, we have to take a step forward also to further secure the judicial institution by having its own independent network, its own independent servers, its own independent, completely divorced from government infrastructure relating to data, information storage, information exchange, even the email. Right now, every single communication can be accessed through NIC, and that's an area of huge concern. Apart from that, this is an area which has been engaging experts from very long time. It's only in 2022, the process started in 2019, that India has started looking closely at it, basically not just the rights group, but also the industry. And in 2009-10, when I was in Law Asia, I was part of a 6-member group which created Asia Pacific Privacy and Data Protection Principles. And it is those principles which were adopted and acknowledged as the basis for the Singapore law on privacy and data protection of 2012. We have taken a long time to come up with a law or a bill, and that too after vesting powers in the government on the executive side, where we took the step without creating enough facilitation and other things that you have an executive dictate that all the data from India cannot migrate anywhere, everything about Indians to be stored in the servers which are based in India. But the capacity of data centers and all was still not ramped up, because I have dealt with the area. I have advised the clients who set up the data protection, centers. So without the infrastructure, suddenly this was pushed as a precondition. So this is the way mostly we plan our things, and that has been one of our weaknesses in the governance itself. Now, the other things I wish to elaborate is that certainly world over, and we are no different, we do not want big tech to be determining how the information is shared, protected, consumed, and marketed. Because data is the new gold. Till some time back, the wars were happening because the petroleum was the gold. Today, data and information is the gold. So that's why the big tech's influence is a huge concern. But in India, as we say, our issues are unique. We are the largest democracy in the world, but at the same time, as Professor Upendra Bakshi had written in a foreword to a book on services law by late Rama Joyce. So his forewords title was Republic of Petty Bureaucrats. So on the one hand, we have the big tech. On the other hand, we have our republic, which by constitution is of the people, by the people, for the people, but in fact, in practice, is reduced to a republic of petty bureaucrats. Because the political executive is temporary, has to face elections every 5 years in states and also at center, and can be voted out. But Article 311 protects the civil servant with a constitutional mandate. And that was given to insulate the bureaucracy from the political interference. But unfortunately, the system has worked otherwise. And it is the bureaucracy, especially the civil services, which holds the real power. And they are, in fact, what we call the state. The Constitution may define it as the legislature, as the executive, or the judiciary. And they have this feudal concept of information hoarding, treating citizens as somebody they govern, and what are due to them as rights are considered either as favors to be doled out or some largesse or something which they decide on entirely different parameters other than the rule of law, or which are subversive of rule of law in terms of corruption, in terms of favoritism, in terms of, as we say, the diversity of India also brings a lot of challenges in terms of caste, in terms of region. All those parameters play, which serve to decimate the concept of equality and subvert the Constitution. Now, in that kind of a scenario, whatever law we may have, unless until we are going to have the watchdog bodies, we are going to have overseeing bodies, we are going to have mechanisms which are not dominated by the same bureaucracy which hoards the information, which takes different actions against the citizens. itself determines which data has to be secured, which data is to be parted, what are the norms, how they are to be implemented. Right now, most of the information which we get is not because they are provided in a formal manner, but through leaks and all. That's how so many information reaches in the media, which should otherwise be in public domain by itself, because transparency is the basic and fundamental concept of a free democracy. So, in that context, when we review this bill, that is where Shyam said, it is better not to have a law than to have a bad law. And also, unless until we are able to force, as a civil society, that the implementation structures, the watchdog structures are independently manned and are not just an arm of the state. Because if the state controls the data, and in fact, in the name of the state, its officers control the data, then citizens' rights, because every information today is there to be in some or other digital form. And trust me, you will, I have handled certain matters in which official agencies, through disgruntled officers or through other considerations, have parted with the information, have taken actions against anyone to get their phone data, to get access to their devices. So there are formal channels of doing that, and there are informal channels of doing that. And there is no mechanism to monitor that abuse. So, looking at all these things, we are going to have this law in one form or the other, because the Indian system works on the basis of majority in the legislature and the parliament. So the bill will be passed, it will become the law. But what we are here gathered today is to understand what are the implications as those who are students of law and practitioners of law, how they understand it, what are the challenges these provisions pose to the rights and also to the businesses, to the economy, how it can, if implemented wrongly, if administered wrongly, can, in the name of state security and other considerations, impede India's entrepreneurial powers to be unleashed. It can send the businesses and the whole sector into a tailspin. Therefore, eternal vigilance, the civil society, the lawyers community which is engaged with the rule of law and has overall perspective, must not only understand this law, understand its implications, but be ever ready to flag its misuse, to flag any distortion which comes up, and to see that they are addressed through an independent judicial system at the earliest. The reason being that the controversies and cases which will emerge from this legislation are not going to merely impact an individual or a party whom you represent. It can be a symptom of a larger malaise. which can affect nearly everyone. So I think we have tried to put together a very good panel of legal professionals and domain experts who are going to enlighten you with various aspects of this law. But I think it is like with every technology-related thing, it is the thought process of dynamically thinking about these concepts, learning to dynamically think about these concepts, because they will pose unknown challenges, unfigured issues till now, and you have to learn how to capture them in real time, how to capture the wider and vaster implications of those, and be ready with the solutions and suggestions for them. Thank you very much. And once again, I thank each one of you for sparing your time today on a holiday to attend this seminar.
Thank you, President. After hearing you, the thought that immediately comes to my mind is you are reminding that we are standing at the crossroad of history, where as lawyers, we know of two kinds of laws. One law which comes out of disruptions, another set of law which actually leads us and gives us the food for thought to somehow emerge out of that situation and deal with it. So there are disruptions leading to law and laws leading to disruptions. We have seen both. We have experienced both. And thank you for warning us at the beginning of today's seminar itself. So we are looking forward to great deliberations, because as you rightly said, we have tried our best to put together a panel which will actually give you the industry insight, the legal perspective, and all kind of aspects that we could have brought to the table. Thank you, sir. Now we have the chief guest for today, Honorable Justice Indira Banerjee, Judge, Supreme Court of India. Just as a matter of formality, although she needs no introduction at all. However, I'm happy to share that her ladyship, be it as a judge of the Supreme Court of India, be it as a judge of Delhi High Court, Madras High Court, or Calcutta High Court, she has contributed a lot to the rights jurisprudence in India. She has delivered a number of landmark judgments, be it striking down legislations due to lacking legislative competence, be it commuting death sentence because the accused never had proper legal aid, or be it protecting the right and dignity and privacy of a little girl who has been made victim of sexual violence. She has protected all of that, and she has not hesitated to travel the length and breadth of the Constitution of India to protect human rights and dignity. We are truly honored to have you, ma'am. I must also inform this audience that she is a life member of Bar Association of India, which makes her presence even all the more special to us. We welcome you back, ma'am, to the family, and we request you to kindly deliver your speech. But before that, I would request our president to kindly give this flower bouquet as a token of our love and gratitude. Justice Banerjee, please.
The President of the Bar Association, the President of the Bar Association of India, Mr. Prashant Kumar, Mr. Shyam Divan, Dr. Pinky Anand, Dr. Anindita Pujari, the members of the bar, my dear students present here, ladies and gentlemen. First of all, I thank the Bar Association of India for giving me the opportunity to be here today to share my thoughts with you. As a member of the Bar Association of India, I was made a life member of the Bar Association in 1999. It gives me special pleasure to be here on this occasion. It also makes me feel nostalgic because the last time I had really addressed the Bar Association was in December 1999, when at that time I was a lawyer of the Calcutta High Court, not a judge. I had presented a paper when the Bar Association of India had been observing 50 years of the Indian Republic. I thank you once again. I am really glad that the Bar Association of India has commenced open house seminars once again. This is important. I have had occasion to participate in virtual seminars, but it is not quite the same because there is always more interaction when there is an open house seminar, and such interactions are extremely important. The Bar Association of India has a great tradition. It is almost as old as I am. I must have been not even 2 when the Bar Association of India was founded on 8th August 1959. On 2nd April 1960, it was formally inaugurated by none other than the President of India, Dr. Rajendra Prasad, in the presence of the then Vice President of India, Dr. Sarvapalli Radhakrishnan, the then Prime Minister, Pandit Jawaharlal Nehru, and others. It was founded, the founder president was none other than M.C. Setalvad. And the association has seen numerous legal luminaries as its office bearers. This fills us with a sense of pride, and it is for us to keep up the tradition by holding seminars of this kind. This association contributes to the development of the law. I, for myself, can say, after slightly over 20 years of judging in constitutional courts, that the best judgments come when there is good assistance from the lawyers. It is not that the judges write all the judgments on their own. Their interpretation of the law is based on the assistance that is rendered by the lawyers. Seminars of this kind enable lawyers and the future lawyers whom I see amongst you to properly assist the court. The Data Protection Bill is extremely important. That has been emphasized by both my previous speakers, Mr. Shyam Divan and Mr. Prashant Kumar. As a matter of fact, whatever I say now would be a repetition. Repetitions can be boring, and I'll try and avoid it to the extent possible. as of now, there is no data protection law as such. All that we have is the Information Technology Act and certain provisions in the information. Excuse me, I'm extremely sorry. My voice, it's a continuation from the COVID times. It just. I'm sorry. So as I was saying, as of now, we do not have any data protection bill as such. The only law which we have is the Right to Information Act. And the Right to Information Act does not even refer to the smartphone. Now, as we all know, and it hardly needs emphasis, one of the most notable technological developments in the last 3 or 4 decades has been in the field of computers, and particularly in the field of information technology. Before I became a judge, the internet had been introduced, but one had to access the internet through the telephones, and the telephones would remain engaged all night. Telephone connections were also not as easy then as they are today. So one could access the internet only at night. Today, times have changed. We have become totally dependent on the internet. Today, perhaps, there are 800 million users in India of the internet. And technical entities, your WhatsApp, Facebook has a new name now. Huh? Yes, I'm not on the Facebook. Google has a large number of clients in this country. Today, much of the business is transacted online. Contracts are executed online. Banking business is also conducted online. Applications, important applications are made online for which one has to disclose personal information. And the personal information which is disclosed somehow does not remain a secret. Because I have myself received all kinds of telephone calls, particularly on the number which I maintain from my lawyer days. Are you so-and-so, you're a holder, you're a member of such and such place? And then I just disconnect saying that I'm sorry. But I don't know how much of data gets stolen in the process. Mr. Divan was just telling me how his mother, a very senior citizen, had been getting calls ostensibly from banks seeking information. Now, the senior citizens usually fall prey, to such calls, and they innocently provide information, thinking that the queries are genuine queries made by a bank. There are many pensioners, there are many women who are family pensioners, and they feel that unless they provide the information, their pension may be stopped, and they answer the queries. Talking about myself, even my telephones registered in the name of the Secretary General of the Supreme Court, or earlier in the name of the Secretary General of the Registrar General of the Calcutta High Court, were not spared from messages. I was just telling Mr. Divan that I am a multi-millionaire on paper. The number of lotteries I have won. Yes. I've never been very good at mathematics. That's been my weak point. So if you convert the dollars into Indian rupees, it would be phenomenal. It would be a phenomenal amount. The thing is, you have to disclose a bank account number. And if someone gets taken away, someone once advised me that why don't you just open an account and give that number, an account which has very little money in it, maybe nothing, and see what happens. I said, you want to know what happens? Through that account, they will get the details of all other accounts that you hold. And you will be denuded of whatever you have in the hope of lotteries. Now these people, they organize, they operate from remote places all over the world. They are seldom within the country. Another problem which we as lawyers often face is cyber defaming, which has become a very serious problem whenever we sit in the criminal jurisdiction. We find complaints of posts which are in complete breach of privacy. On 17th August 2017, the Supreme Court delivered its judgment in Justice K.S. Puttaswamy versus Union of India. The 9-judge bench held that the right to privacy was a fundamental right. It was a unanimous decision of the 9-judge bench. But if we go through the judgment very carefully, of course it is a very lengthy judgment running into hundreds of pages. You will find that the judgment itself has some exceptions to the rule of privacy. Perhaps persons who hold public positions and public posts cannot claim the same kind of privacy as other private persons. A person like me, I would have a dual role. I am an individual. As an individual, I may be entitled to some privacy, but holding a public office, there has also to be transparency. Information and privacy need balancing, as has been stated by Mr. Divan and Mr. Kumar. We have to see where the control, the data bill is also about some checks and balances, controls. There are exceptions, public interest, national security. It is important to see that the power is exercised bona fide and the limits are observed and maintained. While holding that the right to privacy is an intrinsic part of the right to life and personal liberty, and that informational privacy is a facet of the right to privacy, the Supreme Court highlighted the need for the government to examine and enforce a robust regime for data protection. What is required is a balance between data regulation and personal privacy on the one hand, and legitimate state concerns like protecting national security, preventing and investigating crime, encouraging innovation and the spread of knowledge, and the like. But it is extremely important to guard against any kind of encroachment in the into the right of privacy, in the garb of protecting national security, in the garb of prevention and investigation of crime. Since there is only a shade of difference and a lot of overlapping, discussions in this regard are extremely important. Pursuant to the observations and or directions of the Supreme Court in the Puttaswamy case, a committee of experts was constituted, which was headed by the former Supreme Court Judge, Justice B.N. Sri Krishna. And a white paper was released to facilitate comments from the public. Any effective law needs to be discussed threadbare before it is actually enacted. And I quite agree with Mr. Divan that it is better not to have a law than to have a hurriedly drafted law which creates more problems than the problems it solves. Now we come into some of the salient features of the data protection bill. Initially in 2019 or in 2018, there was a private data protection bill, but then there were discussions as to whether it should be restricted to personal data alone. And in 2021, the data protection bill was prepared. It is interesting to come across provisions like expressions like the data fiduciary, the sandbox, I must confess that I belong to a generation which first used a computer. I first used a computer when I was about 42 years of age. Unlike many of you today, very familiar with computers. And as I just mentioned a little while back, at the time of my elevation, the internet had to be accessed through the telephones. It was a time-consuming affair, and very often one could not connect because the lines were so busy. After elevation, time to access the internet actually became restricted. So I am not, though I do use the internet, I do not use the internet as much as you do. So far as banking is concerned, I still write out checks, and was in immense difficulty for about 2.5 months when, because of a burnt right thumb, I could neither write nor sign nor do anything with my right hand. Thank God that has got cured completely now. There was the Joint Parliamentary Committee that was chaired by Shri P.P. Chaudhary, tabled the report on the Data Protection Bill before both houses of Parliament on 16 December 2021. The document comprises of 2 parts. The first half is the report, and the second is the amended bill. The committee deliberated over the bill for 2 years, during which the bill did undergo substantial changes. Discussions of this kind, seminars of this kind, have are very important because it enables you to still give suggestions, because there will be more deliberations on the bill before the bill is actually enacted. And that apart, there is likely to be litigation, a lot of litigation once it is enacted. So you will be in a position to effectively assist the courts in rendering justice. It hardly needs mention. There was talk. My previous speaker, Mr. Prashant Kumar, referred to the bureaucracy and their arbitrary ways of functioning, but then the courts are there to balance. And the constitutional courts, the Supreme Court, the High Courts, these are guardians of the Constitution. They protect the fundamental rights, keeping in mind also the limitations to the exercise of the rights. The new legislation, unlike the proposed legislation, I must say, because it is still at the bill stage, it will deal both with personal and non-personal data. Today, with a lot of business, trade, commerce, being transacted online with contracts, including intellectual property agreements and contracts being executed online. There may be data with regard to processes of manufacture, data with regard to business secrets, the data with regard to the economic position of corporate bodies and other business entities, so on and so forth. Again, there will have to be balancing between the right to privacy, which is a fundamental right, and the right to information, which is perhaps also a fundamental right. You cannot say that it is not. While the data of the individual can be protected, the data maintained by organizations may be open to disclosure if there is an application under the Right to Information Act. To what extent is the information to be disclosed? To what information is the information to be withheld? Of course, even under the Right to Information Act, not all information is open to disclosure. Some kind of information need not be disclosed. Another important thing in the bill is that the government is to follow a timeline for implementation of the law on data protection. The suggested period is approximately 24 months for implementation of the provisions of the statute as and when the statute is enacted. Now comes the question of jurisdiction, so far as the Indian courts are concerned, and the power of the Indian legislature to enact law is concerned. While control can be exercised on data operators, persons storing data within the country, it becomes extremely difficult to protect the data when such data is preserved or stored outside the country. Here again, the law envisages calling upon business entities to set up offices within the country and to set up centers within the country so that they can be brought within the control of the Indian authorities and the Indian laws. But how far this is going to be feasible is very difficult to say. This is something which only time can tell. So a policy will have to be formulated for gradual data localization. I don't think anything can really be done overnight so far as this aspect is concerned. Government is to be asked to establish a mechanism for certification of all digital devices. The committee has recommended that the government should make efforts to establish a mechanism for the formal certification process for all digital and information technology devices that will ensure the integrity of all such devices with respect to data security. Social media platforms are to be treated as publishers and be regulated for the content they host. This is the recommendation, that such publishers are to be held accountable for the content they host. But then again, if you have entities which do not have any base within the country, now internet is a means by which information can be transmitted in a matter of seconds, maybe from India to the opposite end of the globe. This would also be difficult, and policies, rules, regulations will have to be evolved in this regard. There is recommendation of a fixed timeline of 72 hours to breach reporting in breach of personal data. Now, the recommended time is 72 hours. Now, whether this is sufficient or not, whether there should be some provision for extension of the time, these are also matters which require consideration. I think I've taken up a lot of your time. I should conclude, since you have working sessions ahead, working sessions which are going to be addressed by persons who have worked in the area and have immense knowledge. On my part, I wish this seminar a success, and I hope this seminar will go a long way towards effective implementation of data protection laws, rules, policies, and procedures in this country. And I also hope that the Bar Association of India will hold more such open seminars for the lawyers. Thank you very much.
Thank you, Justice Banerjee. It was wonderful listening to you. It's always very educative, and there is somehow a natural flow and belongingness when we listen to you. It was erudite as always. I thank you once again for being with us and deliver such a wonderful speech.